So, Law 365 comes to advise us on the legal essentials that we Microsoft partners should consider when partnering with each other. This is actually the third session in a series of legal masterclasses, which have been found to be really useful in the world of the Microsoft channel. The feedback has been stupendous. Joining us today is Kim Simmonds, the CEO and founder of Law 365, and her colleague Juliet Nutland, a commercial partner at Law 365, who also has a substantial SaaS experience. Just for your knowledge, Law 365 is actually the only law firm in the world completely dedicated to Microsoft partners. Their team use their legal experience to help us as Microsoft partners close deals and manage risks when we get down to negotiating those best commercial contractual terms. So with that, Kim and Juliet, it's over to you. Thank you very much.
Thank you, Lisa. And I couldn't have said that better myself. So what an amazing introduction to Law 365. Thank you. And welcome, everyone. Really great to see some of you again who've been into our previous workshops. So great. Thank you. And for those who are newly joining, welcome. So we wanted to talk about partnership agreements today, as it's a major topic for Microsoft partners that we are seeing now. And I think there are some very valuable things that you can take from this presentation today. We want to really touch on why partnership agreements are valuable. What value do they hold for you? We also want to talk about the different types of partnerships that you might encounter, and then looking at sort of the legal key points in partnership agreements. What is it that you need to sort of be aware of, and how do you navigate these points in the agreements? And then hopefully we'll leave a bit of time for some Q&A. We really want you to sort of get stuck in. So I would just say that as we're sort of presenting the content to you, please just have a think of, jot some questions down as you're going through, and really use that time. We're both very experienced lawyers, and this is your time as well to ask the questions. If we could go to the next slide, please, Juliet. So why are partnership agreements valuable? So I've been working with Microsoft partners for over 14 years, and partner agreements have always been a really important part of the workings of Microsoft partner businesses. But I'd say the last year or so, partnership agreements have really become incredibly prolific. And there's a few reasons why I'm seeing a lot of partnership agreements at the moment. The first obvious one is collaboration. So when it is that you're trying to create more of a collaboration in the marketplace to do the things that you're not quite able to provide services for, you're looking at collaboration as the easiest and quickest way to fixing that problem in the market and fixing that problem within your business. So collaboration is really key. I think people are also just feeling there's more of a collaborative nature rather than a competitive one these days. So people are really coming together to think about what is the best use of the services for the end customers. How do you create a better value proposition in the end, right? So value proposition going into specialization is very key as well. When you're understanding your value proposition, you're really then understanding what is it that you are really good at? What is it that what's your USP out there? And a lot of Microsoft partners, what we're seeing now is that they're creating more specialization. Okay, they're realizing that the jack of all trades Microsoft partner that used to be prolific in the last sort of 5 to 10 years ago is really changing. You know, the sort of traditional Microsoft partner, the sort of reseller of hardware through to the general IT services support is kind of is becoming a thing of the past, and people are really starting to think about what is it that I'm specializing in now? What is it that I can build my name and reputation? When you do that, you realize that you build a really strong relationship with your customer, but you can't provide every single service out there. So again, that's why the collaboration is really critical. The other really important reason why they're valuable is the sort of easy marketing and accessibility to the customer base that you will have through the collaboration and working together in a partnership. You'll have access to their customer base, they'll have access to yours, but you'll also be generating a lot more work between you both. So actually you're creating more value for you both of you. I should just say, I keep saying both of you, but also, you know, partnership agreements can be consortiums. So one of the big agreements that I've worked on in the past is a consortium agreement, which takes the partnership agreement to another level. That's where there were six Microsoft partners in the consortium, all with different specializations, and they really grouped together to apply to do tender bids together and to refer work constantly to one another. So there is that ability as well to really create consortiums, which are the sort of next level up from partnership agreements. And why is the other reason why, you know, partnership agreements are valuable right now is because M&A activity is not kind of where the partners need it to be right now, with the economy the way that it is, the deals and the sort of ability to dispose of your business or exit your business. It's not really a viable option because the deals aren't, you know, the multiples and the values that you're getting at the moment are not where they could be. So actually the sort of secondary level to that is, let's partner, let's figure out how to really create more value at the moment in this economy, and, you know, ride out the wave, if you like. And over to you, please, Juliet.
Thank you, Kim. Super. Okay. Before we start talking and looking at the partnership agreements, we have a quick poll to share with you. So hopefully that will pop up now. We've got 2 questions for you. Have you ever partnered with another business? And if you have, are you confident that your partner agreements cover your requirements? They're just yes or no questions. It'd be great if you could respond. Kim, perhaps you can let me know what the feedback is. Oh, sorry, I didn't mean to do that actually just yet. So, I mean, if you have already partnered, you might be already be familiar with some of what we're going to be covering today. Otherwise, hopefully, we'll provide some useful information for you. And if you're not confident that your agreements are covering what you need, then obviously you know where to look, hopefully, and our email will be at the end of this presentation. So just be aware. Have we had any feedback to share?
Yes. So 86% have said yes, they have partnered with another business.
Excellent.
And it's almost even split on the second question. It's more predominantly no. Most of them are not confident that the partner agreements cover their requirements sufficiently. So I think they'll be really great when we talk about the different types and what they're looking out for in the agreements. That would be really key today.
Yeah, no, that's really interesting. So it's obviously how partnerships expand and change as well over time. Okay, so there are several different types of partnership agreements that can be put in place between 2 businesses. As Microsoft partners, you'll all be very familiar with the Microsoft Partner Agreement. And we think of these Microsoft Big Partner Agreements as the channel partner agreements because they are significant, they have multiple partners, and Microsoft obviously is the creator and owner of a vast quantity of products, and it has to have a full channel of distributors and assistant type services for their products to be used as widely and for it to be as beneficial to Microsoft and then obviously its partners as well. So they are actually just partner agreements, and we'll set out lots of the partner elements that we'll talk about with regard to some of the other agreements, but they will also have information regarding their partner program, and that will be obviously things that you will be familiar with, but the partner benefits, the rebates and the discounts, etc., etc. And obviously there's an element of the consistent communication, shared marketing, commitment, and that will all be set out clearly. So channel partner isn't going to be the focus of the talk today, but it's just worth noting that they're generally considered the big company type arrangements. But actually, you can start to create your own channel partner arrangement in time if you know what you want to put together for your own partner program. So it doesn't just have to be limited to the larger businesses. However, the channel partner agreement is not the only partnership agreement in town. There are many others which can be beneficial to you. So first of all, we're going to look at 3 mainly, 3 that we see the most frequently with the Microsoft partners that we work with. So the referral or introducer agreements, the reseller or the value-added reseller agreements, and the subcontractor. So I'm going to go through each of these partner agreements to give you an idea of what's involved and what we see and what to consider. Okay, so starting with the introducer or referral agreement, this is often seen as a kind of gateway to a more strategic partnership. It's a quite relatively lightweight arrangement. It's sort of, if you're dipping your toes into partnership, you're unsure of how valuable it'll be, this can be a good way to start. So it's used between 2 businesses who are often obviously in a similar sector, but who provide different services. So ideally, you want to partner with a business which has a wide reach, who will be happy to refer your products or services to third parties. These can be mutual, but it will depend on the size and nature of the partner that you're working with. So if you're working with, if you're looking to a partner who's already got quite an established name and an established market, well, that's brilliant, because obviously you want to be able to get to those end customers, but they might not be keen to have you as a referrer of their services, because they'll feel that they're already well enough known. So that's quite common for those to be one way. But obviously you might be working with other similar sized Microsoft partners who do a slightly different thing, and in those circumstances it can be mutual for you both to provide introductions for each other. So the agreement itself will set out the terms and conditions for the arrangement, and payment, which is obviously key, is by way of either a referral fee or is commission based. So will be depending on sales or the execution of a third party agreement at the end. Okay. Reseller VAR agreements. So Del Boy, he's a reseller, but he wasn't, I think, an authorised seller of another party's product. So that's the important distinction to make. So these are similar agreements, the resellers and the VAR arrangement, but with one important distinction. One of them is where you are putting your products or services together with the other partner's product or service, and together then that is being onward sold and creating some value add. So you'll be working together with this, and you just need to be particularly clear on these agreements when it comes down to the ownership rights of the end product or service, and any licensing that goes around, perhaps the creation of a new name or logo for these products. You'll probably already be familiar with the reseller type arrangements, because I'm sure many of you are onward selling other third-party software. So it's a little bit back to front of this slide, so apologies. Subcontractor agreements. So you're likely to be familiar with subcontractor arrangements in one way or another. You may have been a subcontractor for another entity. Lots of our clients are subcontractors to larger entities under the government contracts, for example. But subcontractor agreements can also form partnership agreements, because you are in a partnership in a way anyway when you're a subcontractor. So you've got to think about things from those terms. But in addition, if you're working with another party and you're providing an outsourced skill, or you're looking for that skill yourself to outsource, this can be done via a subcontract agreement, and then layering a sort of partnership arrangement on top of that, because if you think that it would be good to work with that third party on multiple projects and not just the one currently in anticipation, so you don't have to limit yourself to this one subcontract. You can put together an overarching partner agreement and then have the separate flow downs for each of the subcontractor agreements where they relate to the main contract. So you might have, for example, an implementation partner who could provide some implementation services for your particular product, and then the agreement will contain the main partner obligations and the marketing. But then you have to make sure that you're flowing down the obligations between party one, you and the customer, and then to party three, the subcontractor, because obviously ultimately you must remember that you are liable to the end customer in your agreements, and so within your subcontract you have to ensure that the subcontractor is liable to you to the same extent if possible, but you just have to make sure that you check for any of the potential liability gaps there and plug them. Okay, so we've just had a look at the three models, of which we've got a poll now. So which of those three models do you think will be the most relevant to you going forward, or have been the most relevant to you? If you could give us your responses, that would be great. I'll wait for Kim to update me.
Yeah, 100%. So, okay, I'll give it a few seconds. It's a few people.
Getting keen.
Yeah, getting keen. All right. I think we've got all the responses. So 50% introduction referral agreement, Juliet, and then you've got an even split 25. Oh no, okay, it's changed again. 40% introduction, 40% reseller, 20% subcontractor. So it looks like the introduction and reseller are the two key ones there.
No, that's good. That's interesting. It's at least we know that these things are looking interesting to people on the call, and hopefully we'll get some further information about that. So I love this slide. So what are the key provisions to look out for in the partnership agreement? So what we've talked about is an overview of what they are, but we need to just have a quick look at the legals that you will always need to keep an eye on within any of your partnership agreements. So the key areas to look out for, and these are sort of just general commercial points, which should be in all of the partner agreements and are likely to be in many of your other agreements as well. So first of all, what's the most important thing in your agreement is payment. When are you going to get the money? What is it? How much is it going to be? And when is it due? It's likely to be linked to third-party contracts, so that needs to be clear as well as to how the payments flow through. And are there consequences of any late payments? Will you be putting will interest apply if it's late to pay, or will there be consequences of termination for late payment, or even a sort of suspension of the partnership? These are just things to consider when you're putting these agreements in place.
Juliet, could I just quickly say something about that as well from my experience? When you're dealing with commission schemes, so in the introduction and referral agreements, you're going to be looking at what forms commission. It's really important to look at how you're defining, firstly, how you're introducing people. So is it sort of 12 months from the first moment that?
So this is on my next slide.
Yeah,
on the
that's fine. With the thank you. No, but the commission part of that is the reason I'm saying it is because when you're looking at the commission linked to that timeline, you're also looking at how do you define commission. So is it the net profit position? You know, how are you actually defining that, and how are you counting net profit? So what is it that you're taking? What costs are you allowed, or they allowed to take away from that before they're actually getting the 10% commission? So there is a bit of thought as well to look at the payment around the commission scheme.
Yeah, absolutely. That's absolutely right. Yeah, thanks, Kim.
No problem.
Okay, so moving on to term and termination. So is there going to be a fixed duration for the partnership agreement? Is it going to last for a short amount of time, or is it just going to kind of roll on? It's worth putting some consideration into termination for convenience. Partnership, these sort of things, more appealing in a partnership arrangement, obviously less so in your bigger agreements, because you've not got a large project rolling underneath it. So you might, if the partnership is not working, you might want to exit. And then obviously any other ideas for how you're going to terminate, so such as material breach of any of the terms, misrepresenting what they're reselling or what they're doing, and or any insolvency as well. So liability always needs to be covered off. There should always be a cap on liability within your contracts to manage your risks, even when you think there are limited risks. For example, with the introducer, it's always worth putting a general cap on liability, and we generally suggest between 100 to 125% of fees sort of paid or possibly payable in the 12 months before the risk has arisen, or the claim has arisen. So it's definitely something to include. Otherwise, if you don't include a cap, then the liability is unlimited, and no one really wants to be in that position. Governing law, not particularly interesting one, but makes sense to keep it as England and Wales where possible, so because the contract is likely to have been created under English law. So in the unlikely, hopefully, event of any legal action arising, the intention of the contract will be interpreted appropriately by the courts if it stays in England and Wales. And then how the relationship works. So this is something that is really particular to a partner agreement. So what is the process for the partnership? What are the obligations? So, and what are your expectations? And these could be different in the different types of partner agreements. There may be little by way of obligations under a referral agreement, for example, but it's still worth setting out if you do have certain expectations and obligations between the parties, because that is the main purpose of the partner agreement, that you are both being partners and you're operating cooperatively in the way of the partnership agreement. So it's good to have that set out expressly. Right, okay, so in addition to the general terms, so these are sort of specific considerations that you would need to think about for the introducer and referrer agreements. So Kim was mentioning before the introduction period, and that's something that you need to consider, like how long is that going to be? Because it's fabulous that someone's going to go out and introduce you to another business, but what you want to be able to do is you want to be able to action that introduction. It's no good if the introduction period is forever after they introduced the business, but actually their the relationship contact that they provided didn't actually work for you. So what we tend to do is we would put a limit on that time to about 6 months, which should usually allow for discussions and negotiations and hopefully conclusion of contract with an end customer. I mean, we like to hope that that would all be a lot less, but I think 6 months gives enough time. And you need to be clear within the agreement who the introducer can go after. Like, they cannot go to any of your existing customers or any of the affiliates of your existing customers or anywhere else that you think you might already have an in, because you don't want to be paying commission when you've already got some contacts. You really need to think about how you might want to define the prospective clients that they are able to go after, or at least make sure you exclude where you don't want them to go. Ideally, this kind of arrangement should be non-exclusive, gives you the option to work with more than one introducer. Just be careful, though, be mindful that you don't work with an inordinate number of introducers, but more than a couple of introducers could, if you've only got a limited number of sort of products and services to sell, get you into hot water, because if they're all going after the similar end customers, and you might end up finding that they've all introduced the same entities, and then instead of paying the percentage that you think you're paying it 3 times or whatever. So you just need to be careful that you're managing the partners and that your relationship with the partners and the limit on the number of those. You'll need to set out the referral process. How is the referral going to work? How is the reporting going to work? Are they going to be reporting back to you regularly? And are they going to be listing the companies that they've approached? And which contacts did they speak to, the title of that person, and all the information that you think you need to make sure that you can actually act on the referral that they've provided. And then commission. So yeah, how is the commission calculated? So yes, it's on the net value. So need to consider to think about that, what you're going to exclude, and also how much is the commission going to be. So we see sums of around 10% of the net profit banded around, but then you have to consider, what is it going to be 10% of? Is it going to be 10% of the first invoice? Is it going to be 10% of the services provided in the first year? It's just something that you need to be clear about in the agreement. You want to be careful not to attach the percentage to a full contract value, as it might be a contract that's a multi-service contract or a multi-year contract, and then you're paying an additional percentage which could add up over the years. So it's just something to think about. I mean, I know some people say, well, you know, if we've introduced you and it's a really significant business, then that's what we should be getting. But I would say 10% of the first year is probably enough. And then when is commission payable? So commission should only be payable once you have received that money in the bank from the end customer, and not on signature of the third party agreement. They might be slow to pay, they might decide not to they might terminate unexpectedly early, etc., etc. So you have to make sure you've got the money in the bank before you pay any commission. Okay. Right, so now we're moving on to the resellers and the VARs. Okay, so some of the things we'd normally consider is, again, exclusive or non-exclusive. I think generally we wouldn't recommend entering into an exclusive arrangement. You have to be careful with resellers and exclusivity, because then you can run into competition issues, but you can have an exclusive arrangement if you want to for a limited period of time, and or for a specified territory for a limited period of time. So that's just something to think about. But generally, we would think that a non-exclusive arrangement would be better. So we'd also look to put non-compete clause in. So if you're working with a reseller and they're selling your product, it's worth considering including this, because you don't want them to be creating something which competes with your product or your service, or reselling some competitor products alongside your own. Now, it's a difficult market, and that's not necessarily always going to work. So ultimately, if you think the reseller has got other products which might compete, but somehow, you know, you've got a slightly different angle and you're happy with that, then that's fine. It's not a no-go. It's just something to consider. And then, as mentioned before, all the duties of the reseller. So what exactly are you expecting them to provide, or are you expecting to provide yourself? So are you expecting them to be promoting the products and services? Are you providing marketing materials? Are you expecting the partner to provide marketing materials? Are you going to be displaying logos on each other's websites so that parties know where to go to for the products? Will you be linking to each other's sites? Are you expecting a number of sales quarters monthly? Are you just hoping to get some underway? If you've got some specifics and you want to attach some termination rights for not achieving that, then that's fine as well. Just really getting to grips with exactly what it is you want to achieve under a reseller. You don't have to be too prescriptive, but particularly if you are providing any element of exclusivity, as discussed before, this is definitely something that you would want to keep in. So intellectual property. So it's kind of relatively straightforward in that where a third party is reselling, then each party will own its own intellectual property, and the reseller is just licensing on your products or services, or will not own any IP related to that. Just need to remember that everything needs to be flowed down to the end customer. So any protections around IP need to be flowed down, and any other elements that you would like to flow down. These are often flowed down by way of a EULA, but they can be just specified flow down terms within the agreement. Okay, non-solicitation. So we generally encourage our clients to keep non-solicitation clauses in many of their agreements, and this is because people are essentially your biggest asset, and you don't want the businesses that you're getting close to, so the other partners, to come along and poach your staff. It slightly sours a relationship, and it can create a significant additional expense. So hopefully you can include non-solicitation clauses. And as I've mentioned previously, the flow down obligations, and an obligation on the reseller to ensure that the end customer does sign up to either the EULA or the flow down terms that have been specified within the agreement itself. Okay, moving on to the value added reseller. So it's all of those things that have already been talked about. And then responsibilities with regard to the marketing of the product. So who has got those responsibilities, and are you working together to do that, given that it's a combined offering, or is the value-added reseller, are they responsible for that element of the arrangement? And are you going to be deciding on the new name for the product together, etc., etc.? You need to consider who owns what in those situations. And then if it's a software product that's being combined and resold, then both parties need to be clear on what their obligations are with regard to the updating and upgrading of their products. So if you're working on them separately, then if it's being updated and then provided again to the reseller, both parties need to make sure that they continue to remain compatible for the duration of the partnership. So, subcontractor agreements, these are some of the specific considerations. Okay, so many of the key partnership obligations that I've already discussed will set out the basis for the partner arrangement that I talked about before, which might be levelled over the top, to identify when you're going to use the subcontractor as a partner, if you're going to prefer them to other subcontractors, whether there's going to be an obligation that you'll try them before you look elsewhere. And you might also need to identify whether there's any intellectual property which may flow between you, particularly if they're providing implementation services. So that can be dealt with within the partner agreement at the top. And then also we advise, if possible, for an indemnity to be put in place so that the subcontractor will be liable to you if there's any losses under the main agreement. So that's a kind of general indemnity that we would like to see. But in addition to that, when you're looking to use them as the subcontractor, then flowing down those obligations from the main agreement is really key. And you might want to try and agree in the partner agreement that all of the flow downs from the main agreements are done by way of a kind of back-to-back agreement. And that way it's basically you've got your main contract, and you are essentially saying that where your name is, then their name will be, and your name will be the name of the customer. So essentially they're stepping into your shoes and having exactly the same rights, responsibilities under that contract. And that is the best, the neatest way to sew up the subcontractor arrangement. It's not always possible. An agreement may contain many obligations, etc., that aren't going to flow down to the subcontractor itself. So it might have to be a slightly piecemeal approach, but that's kind of like easy fix, if you like, and make sure that they are on the hook. And also, you will need to ensure that you have the ability to terminate the subcontract if the main agreement is terminated. You absolutely don't want to remain responsible for payments to a subcontractor if the main agreement is no longer in existence. So that's sort of all the terms that I was going to talk about with regard to the agreements, and I'm going to hand back to Kim in just a second. But just to say that these are sort of elements of agreements that we normally see, but you don't have to necessarily restrict yourself to these three sort of separate agreements. These are just things to consider when you're considering a partner arrangement. So if you've got a partner in mind, and they will be useful for one or more of those elements, then it can all be put together in one agreement. And we actually ourselves sometimes use a multi-option agreement for clients when they're contemplating a variety of different options for partners, and then they just identify the roles and responsibilities. So this is kind of these are the ones that are often chosen, but the beauty, if you like, of the partnership world is it can be whatever you need it to be, so we can just make sure that all the elements are covered off for you. Okay, I'm going to hand back to Kim now.
Thank you, Juliet. That's brilliant. Yeah, and just on what you've just said, these agreements can get quite complicated because obviously there are a multitude of options available to you guys. And as you can see from Juliet's presentation, there are some nuances that maybe you might oversee just because, you know, as lawyers, we have to look at a most pessimistic state. So we're always looking at what things could go wrong, how grey an area can you achieve with your customer, and how do we plug that gap so it becomes a lot less grey if things go wrong. And you know, when you're dealing with potentially vast sums of money, when you're exchanging hands for introductions and referrals, you really need to make sure you're absolutely nailing the commission scheme, the payment terms, even the termination rights. You know, if your customer terminates within the first 3 months because you've got a main agreement with your customer that allows them to do that, what position do you feel the introducer needs to be in? You know, they will complain about that, but you won't have the money coming in from the customer. So, you know, it's not an easy thing to put together yourselves. And I do think these are one of the areas of business and relationships that actually do need lawyers to help you really think about these things and get it right from the start, because then you generate a fantastic partnership with that other entity, and you're going from a great place and a more safe place. So that's just a sort of a quick summary of what Julia was saying. Obviously, as I sort of presented at the start, you know, the reason why we think this is really important nowadays is because the market's becoming more collaborative and specialized. So therefore, you want to keep your customers really happy and provide them a whole range of services that maybe you don't want to be doing yourself in-house because you're specialized in one area. So this is a great way to keep that client with you for a long time and build that relationship up, and they themselves will refer work to you if they're happy and enjoy the experience with you. So it really can generate quite a big value for you as a business, which obviously is great on exit. So the exit opportunities are twofold. One, that you are generating bigger values anyway by bringing more work in, and keeping clients with you for longer, which any buyer would like to see. But also it shows any potential buyer that you can actually be in partnership with other entities. There's a big buy and build landscape out there for Microsoft partners where, you know, especially private equity, they like to buy different types of businesses and put them together and work together. So if you're able to show that you've already been working successfully with other businesses out there, you're going to be a much more attractive proposition for people to come in and work with the business. So there's some really fantastic things. The other little points here was just, you know, great learning opportunities to see how different companies offer their services. You know, again, when you collaborate, you're always going to see different things and learn different things, and that's just emphasizing that learning opportunity and creating bigger pools of customers. So that's a quick recap, and I think we're going to go to Q&A now. So we're going to open up the floor to you guys. Hopefully we haven't bored you too much, and that you've got some questions that we might be able to help you with. Thank you. Anybody have any questions?
I'm just having a look here to see. We've got one question. We asked, do you cover Ireland?
So we don't cover Ireland, unfortunately. England and Wales is the only jurisdiction that we cover. But what we often do for some businesses that are based elsewhere, we can still generate the agreement. We have to put it under English law and Wales, but you might, you know, take the risk of changing that to Irish law. But you would probably have to just get someone locally to just make sure that it's enforceable under your set of laws. But other than that, we can still help you. It's just whether or not you would like to, you know, if you need more sort of local expertise there.
Okay. Kim, Juliet, I see we have some clients of yours in the forum already, and they've said that you've written their contracts, so they're not really worried about anything too much about that.
Excellent. That's good.
So that's a good testament.
Yeah, that's great. Yeah, and look, you know, just as a rough price guideline, so I think it's always worth people understanding, you know, what's actual cost involved. You know, we start these kind of agreements depending on how extensive they are, about £2,000. As you can see, they are quite intricate and they need a lot of thought and planning. So they do take some time for the lawyers to go through with you, but once they're done, they're absolutely invaluable to you. And it will be great if you have the right partner agreement. So if you do think of exiting at some point, you can show a potential buyer that you're not leaving any gaps or risk for them to take over that partnership as well.
Okay.
Anything else you want to add, Juliet?
Nope, that's fine. Thanks, Kim.
Okay. All right.
Okay. I think, well, I mean, I think that if there's no more questions now, then potentially we might get some questions through to Lucy and I. Otherwise, our members might reach out to you. Thank you so much for another very engaging scenario. You always say that you hope you haven't bored us, but there's not one single second that's boring in any of your sessions, to be very honest with you. Even as a partner, I do sit here and go, oh, have we done that? Note to self. So thank you so much for your attendance today. Thank you so much to the audience for coming through and participating in your polls. I do find your polls very revealing too.
Yes.
So thank you so much, and thank you in the background, Lucy, for managing those polls.
Oh, we do have one question that's come in actually. I don't know if anyone's got.
Oh, here we go. Yes, at the bottom.
Yeah. In addition to setup of contractual terms and conditions, does Law 365 provide service and support for any consequent litigation? So we don't do litigation, unfortunately.
First Q&A first, not in this chat.
Okay, yeah.
Fair enough. No, we don't do litigation. We can help with initial letters and sort of trying to resolve the dispute, but actually if you can't get to resolution then, and it needs to go to litigation, then unfortunately no, we aren't able to help you with that.
But we do know some firms that can help you if you want to contact us.
Yeah, or insurance.
Yeah. All right.
Thank you. Thank you so much, ladies.
Thank you. And thank you very much, everyone, for attending. Really appreciate it.
Yeah. Thank you. Thanks very much.
Have a lovely day. Bye-bye.
You too. Bye-bye. Bye, everyone.